Silence, culture eyes. Part heard appeal in Elan-Cane and Secretary of State for the Home Department and another.
Yes, Mr. James.
My lady, my lords. I'm going to start with some of the basic principles under Article 8, and that's going to be more of a sketch than anything, apart from a bit more on margin. Then I'm going to apply those principles to our present context, still in the territory of Article 8, and then much more briefly in relation to Article 14, and even more briefly in relation to common law and or public law challenges, and then I've got a bit at the end to deal with the costs appeal, or the cross appeal, but that's going to be...
Well, I'm afraid it sounds like you're going to be competing with the men with the drills.
I'll try and keep it up.
If it gets intolerable, then we'll actually have to think about what we do.
So starting with the principles in Article 8, if I may, the positive obligation, as the court will be well aware, sometimes involves the state taking action in the sphere of dealings between private individuals. So that's one sense in which it's used in the Strasbourg jurisprudence. But in a context like this, it means something different. It means, in essence, that respect for private life can only be shown by imposing on the state not merely a duty to refrain from taking action, but imposing on the state a positive obligation to do a particular thing. That's the sense in which we are dealing with the concept of positive obligation. Or to put that same point another way, the taking of the step in question is an essential precondition to affording proper respect, which is the word used in Article 8. And in the present sort of context, the European Court has now coalesced around the analysis being, in effect, that positive obligation, consideration of whether that sort of positive obligation should be imposed, as opposed to going down the route of analysing it as a negative obligation on the state, with all that entails. And we see that that's their preferred analysis from the Grand Chamber decision, and it's one of the few, if not the only, Grand Chamber decision that's of real interest as far as we're concerned, which is in Bundle B at tab 40, and is Hämäläinen and Finland. Can I just invite you to take that up very briefly for this purpose? So Bundle B, tab 40. And we see that the Grand Chamber here analyses, you see it's Grand Chamber from page 55 of the Law Report 1488. You see the number of judges and that it's Grand Chamber. The analysis as to their preferred analytical route you see considered between paragraphs 62 and 64, with the conclusion as to their preferred analytical route being set out at paragraph 64. So the Strasbourg Court is thinking about these issues by thinking about whether or not it's an essential precondition to respect that you impose the particular obligation which is asserted. That's what this preferred analysis ultimately comes down to. And the question that then arises in principle is, well, what are the factors or the themes that they're particularly interested in deciding whether or not a state should be under that sort of positive obligation? And there are essentially three factors, or three heads, within that analysis when deciding whether or not to impose such an obligation. The first of them, and you see it critically examined again and again in the case law, is a focus on the position in other states. And they focus on that for understandable reasons, because in this sort of territory one is dealing with societal values and attitudes which may develop over time. So we're in the area of evolving rights. And the central question which they consider, therefore, is as to the state of evolution, as reflected, if you will, to take the well-known shaper of international law, as reflected in state practice. And essentially the question is whether or not there is clear evidence in relation to the alleged positive obligation of a consensus. That's the word that's repeatedly used. I take it directly from Hammerleinen at paragraph 67. Is there clear evidence of a consensus in other member states, supported or not by a broader international trend? So the focus is on Council of Europe, but with a broader international trend sometimes being relevant and analysed. And so if there are different systems or a different state of development and a lack of consensus, that is a powerful indicator, as the case law demonstrates, that there is no such positive obligation as an integral part of according respect for private life. So that's the first of the factors focusing on the position in other states. The second area of focus is on the state itself, here the United Kingdom, and its systems. And the focus has been in particular on the coherence of the administrative and legal practices within the domestic legal system. And again, you see that from Hammerleinen at 66, both where it specifically refers to the coherence of administrative and legal practices as an important factor, and also in 66 in the reference to the alleged obligation and whether or not it's narrow and precise or broad and indeterminate is the language used. But both of them reflect that coherence aspect. And they also consider, and for this purpose, if you have bundle B still to hand, can I just invite you to flick back to tab 29, which is the Rees and the United Kingdom decision. Just to highlight a couple of paragraphs, 43 and 44 on bundle page 1229, where they consider the burdens on the state and the extent of departure from the general practice of the state on similar matters that would be entailed in imposing the positive obligation. But that's simply an example of them considering that sort of issue. I say the precise detail of how they do it in Rees doesn't matter terribly, it's that they're doing it. That's, for present purposes, the important thing. So that's the second of them, the focus on the state and its systems. And thirdly, they focus on the individual and the impacts on the individual if the positive obligation is not imposed. And they consider whether they are dealing with essential aspects of private life. That, of course, chimes with this being a positive step as an essential precondition to respect, if you will. You see that from Hammerleinen at 66 again. And they focus on the nature and extent of the prejudice, or of any prejudice. So it's a relative question, not merely whether you are dealing with something which can be characterised as being within the scope of Article 8 rights. They focus on relative impact. And one gets that perhaps most clearly from a case called Sojourner, and that's in the same bundle of authorities, Sojourner in Finland, tab 31, paragraph 42, bundle page 1296. And again, how they examine it in that particular case doesn't terribly matter. It's that they're doing it that is important for the purpose of this principle.
Going back, if I may, for a moment to your first head, the consensus, is there any guidance as to, so to speak, what degree of, how many people have to agree before you can talk of having a consensus?
Well-
is it done by a majority, or is it just left as a very vague
When does a trend
concept?
become a
When does a trend
consensus?
become a
Yeah, well, I mean,
consensus?
that's an entirely fair philosophical question, but I suspect it is a philosophical question. I'm not sure there's a terribly clear answer to that in the case law. I'm going to come back to this theme
Right.
in the context of margin, where it applies
Yes.
directly, and show you some of the authorities. But I think the best one gets in relation to that question are illustrations as to what is enough and what isn't enough.
Yes.
But again, they're not set in stone. It's a bit like the court setting a broad principle and then trying to work out how it works through by examples in previous decided cases in our jurisdiction.
Yes. I mean, a literalist might say you need 100% agreement to have a consensus, but I'm sure it's not.
That's not my case.
It's not your case, and I'm sure probably a majority might count as a consensus. But anyway,
Yeah, I think one does. We'll see, as I say, when we get to the case law, we'll see how the numbers split. And perhaps the most interesting development that helps you with that is the development from Rees to Goodwin,
yes,
when the change actually is made. So no again in France, yes, finally.
finally you get there. Yes.
In relation to transsexuals, and there plainly had been a significant development in terms of that. And then you have the statement, I think it's in paragraph 85 of Goodwin, but I'll come to that if I may. So I think the answer to my Lord's question is there is no direct principled answer to that question, and the best that one can do is to see how they've applied it in practice to give you at least a flavour of it. And I'm sure they wouldn't want to put themselves in a cage. So maybe there are good reasons for not.
Oh yes, yes, I understand.
Remember, pull is strong, maybe the consensus gets lighter. So focus on individuals and impacts I was on. Nature and extent of prejudice you get from Sojourner and Finland, para 42, as a factor. And I'll come back to this when I come to consider this part of it and apply it to our particular context. But this factor encompasses those features that the judge analysed in effect as a preliminary question relating to the engagement of Article 8. So there's a question of a form, perhaps more than anything, as to whether or not the court does or it doesn't. And in some cases it does, and in some cases it doesn't analyse Article 8 engagement as a separate issue. I think the trend from the case law there, it's not entirely clear. The trend from the case law appears to be that when they're thinking about whether it should be analysed as a negative or a positive obligation, they tend to go for engagement, even if ultimately they plump for positive. But I'm not sure much is going to turn on it, because the factors that impinge onto that engagement analysis are equally relevant and would be taken into account on this third factor.
It's a bit of a formalistic point, isn't it?
It is, as I hope I've fairly accepted, because I'm not saying that any things get cut out from this third factor if you analyse it pure and simple as positive. It's of course important to note that a positive obligation, so those are the three areas that they look at, it's important to note that the positive obligation can be imposed at a higher or a lower level of specificity. Some recognition of status versus doing a particular thing, according respect in a particular way. And of course, in relation to each of those three factors, different aspects may be in play and may need to be analysed, and the interplay between the three may come out differently depending upon your particular context. The point perhaps ties back into positive obligations and consensus by asking whether there is consensus as to the step which it is said the state is positively obliged to take. And that of course goes in part to the point I'll come back to about their choice of target in this litigation. as opposed to having set themselves a broader and more difficult task of recognition for non-gendered or non-binary people. It's that issue which I'll come back to. But our submission is that they have to show a positive obligation to introduce this step, i.e. the introduction of X on the passport to succeed. So with that brief sketch of the three factors that are in play, can I turn to margin and the application of margin when you're balancing between them at any particular point in time. And my submission is that the margin is at its highest under the ECHR system when the court is dealing with developing societal values on which real consensus, if I'm allowed to introduce that adjective to answer my Lord's question, has not yet been reached, especially amongst Council of Europe states. And the margin at its highest there, the principal basis for that submission is that there can be differences between states legitimately. And the flip side of that, of course, is that the European Court in that situation does not impose solutions, but it allows differences.
Is there any example where a lack of consensus about the way individual member states meet a given problem arising under Article 8? That's not sufficient, is it? The margin of appreciation allows states to greet a problem, address a problem in different ways if a positive obligation arises.
My Lord, if the question is, I suspect my Lord's question is whether or not the margin applies only at the stage of implementation or whether it applies also to the very existence of the obligation itself. And my submission is, I hope that's the question, my submission is the latter, if that is the question.
As always, you phrase my questions better than I do. But what I'm trying to get at is this.
Or perhaps he's phrasing it how he'd like it.
The fact that different states meet the problem in different ways. Here, for example, by having no gender marking on their passport, or by having a gender marking that includes a third gender, or and there might be other solutions. The absence of a consensus as to the specific step taken does not, it seems to me, remove the fact that there may be a consensus requiring the problem to be addressed in one of the acceptable ways. I'm not saying there is one here, I'm saying that's how one thinks of the consensus, not the detail of what is done.
My Lord, I think the answer to that is that the case law indicates, and I'm going to come to it in a bit more detail in a moment, but the case law indicates that they have looked at consensus in both of those senses, in both of those ways. Sometimes, and perhaps understandably they've done that, because there may be quite an ephemeral distinction, if distinction at all, between focusing on the specific obligation, saying is there a consensus in relation to that, and the sort of broader issues that my Lord has identified. What I think I can accept is that if there is a consensus in relation to the basic proposition, thou shalt afford respect in whatever ways, you still have some margin, and we'll see this said in terms, I think, in Goodwin.
As to how to implement
Exactly so, but non sequitur the other, that works backwards, if that makes sense. So non sequitur that you can then say that therefore it's only confined to the implementation steps. The case law, as I will be submitting, does indicate, and I'll come to this very specifically, that consensus is treated as being relevant in the broader question, in the question as to whether or not, I don't know, it's just in relation to transsexuals, have they moved to a place where you're required to accord them status in your law? That was the very essence of the movement and the debate between Rees and Goodwin.
Well, in a sense, that's got to come first, because then what you do about it is very much.
It has. So I think, in a word, the answer to my Lord's question is that there is indication in the case law that they treat as relevant to both of the aspects you identified. And if you are in a context where there are developing societal values, there isn't yet a clear consensus of that kind in whatever way, there's plenty of case law highlighting the breadth of the margin and the factors playing into that breadth. We analysed those in our skeleton at paragraph 28. I just give you the reference, including in particular the reference to Lady Hale's judgment at paragraph 41 of McLaughlin, again, I don't invite you to turn it up now because it's for a tolerably basic proposition. But McLaughlin is in bundle A2, tab 22, and the relevant paragraph is 41. So if you're dealing with an area which the Strasbourg Court would regard as involving, evolving social values and legal rights, the margin is wide, reflecting the basic principles underpinning the ECHR, that uniformity of the pace of development in those sorts of areas is not a feature. Of course, they will examine whether the thing has developed to a point of some solidity, because that's an integral part of treating the convention as a living instrument, which is referred to in lots of the case law. But there is a margin that is wide up till that point. And also, if you're striking balances between private and public interests, that's the inherent in the whole convention, is the balance between private interests and the general interests of the community, oft repeated in this context as in others. And to put both of those points in a slightly different way, you have language being used, including, I may say, given one of the submissions my learned friend made yesterday, in Hammerlein and at paragraph 67, sensitive moral or ethical issues. Those sorts of questions attract margin for the principal reason that there can be different views amongst different states, and that is acceptable until the thing has hardened to a sufficient degree. And the reason perhaps that margin features so broadly in a context in which you are analysing fair balance to determine if a positive obligation should be imposed under the ECHR is because if you do impose that positive obligation, there is in effect, that in effect implies a conclusion that there is only one way of according respect, or there is only one possible answer to a broader question, and that is a high thing. Because in our particular context, if that is the conclusion, it effectively means that all countries in the Council of Europe that do not allow for X on the passports are in breach of that positive obligation. And if that is the conclusion, not merely does it have that broader consequence, which would be surprising as for reasons which are obvious if lots of them don't. If that is the conclusion, it's the conclusion that the step needs to be taken immediately, has to be taken now, and cannot be postponed. So there is a present obligation to do the very thing. And we see all of those themes reflected in the development of the case law. The learned judge analysed and reviewed the relevant Strasbourg authorities with some care in the judgment at paragraphs 85 and following. And he was right to conclude that it showed a cautious development towards limited recognition in that context of the rights of transsexuals, but based only on a solid consensus amongst the legal systems and administrative practices of member states. So the Strasbourg Court was testing over time, if you will, the social, ethical and legal controversies that are associated with that sort of issue. My learned friend, I think, submitted, and it goes to my Lord Justice Irwin's question, that the margin only really applies at the stage of implementation, if I can use that language, and not in relation to the question whether there's a positive obligation in the first place. And my submission is not so. The consensus is directly linked to margin, and margin is applied to the question whether the positive obligation arises in the first place. If you still have bundle B to hand, and you go to Rees at tab 29, the relevant paragraph for this purpose is paragraph 37, cited, I should add, by the judge in the judgment at paragraph 86, para 37 of Rees. Can I just invite you to remind yourselves of that paragraph? I'm sure it'll be familiar from the judge's judgment, if not all from reading the case in the rule. And the first subparagraph leads into the second, as you see, and it's the second which is interesting for this purpose, because you see them analysing the different ways in which different states have reacted to the problem or to the issue. Accordingly, this is an area in which the contracting states enjoy a wide margin of appreciation as to conclusion and breach. That's the analysis in Rees.
I mean, presumably, would you agree with this? The court is not a purely passive vehicle, so to speak, of just reflecting what stage development has reached. Can it have a positive role of its own in seeking to shape and develop the way that a particular matter develops? I mean, in a way, that may be inherent in the concept of consensus being less than 100%. So once you reach a certain stage, the court then says this now has to harden into law from its starting point as mere diversity of practice.
Yes. My Lord, I think it would be a brave advocate that suggested that that a court, particularly this court perhaps, i.e. the Strasbourg court, did not bring its own values to bear
That's rather what I was
on a
thinking.
particular issue. So the answer to my Lord's question is probably yes. But they are nevertheless astute for the principled reasons that I've given, that it should reach at least a certain point of solidity before they jump.
Yes.
And one sees that very clearly, because the plight of transsexuals, if one analyses it in those emotive terms, in Rees was sharp. And it remained sharp in the French case, it remained sharp in Sheffield and Horsham, but it took until Goodwin, whenever that was, 2002, so some considerable time thereafter, almost over 15 years later, for the court to jump.
Much of the seeming plasticity and incoherence of European statements of principle may derive from the business of herding jurisdictions.
Of
Herding jurisdictions towards an outcome. That's what one sees.
my Lord, one does, and again that perhaps plays back into my Lord Justice Henderson's question. I accept in principle that there's a degree of herding going on. One sees it, for example, in the final paragraphs of the Rees conclusion, which said it's a kind of final paragraph of passage to India, not now, not yet. But bear in mind, we're looking over your shoulder, and we're going to come back to this, as they did in the French case, and they did in Sheffield and Horsham, but it was only when they got to Goodwin that they jumped, and the key feature that had moved was that consensus. So they are astute to the constraints, and it's right that they should be, because it is an integral part of their jurisprudence that states are within the margin, allowed to develop in their own ways until the thing becomes clear and the living instrument can recognise a branch as properly grown. But the point I'm on now is a slightly different one, which is at what stage does it apply? Is it to the imposition of the positive obligation itself, or any positive obligation itself, or is it as to simply the manner in which you go about doing that?
You're saying that the positive obligation is not as is submitted on one level, that establishing the positive obligation is almost a concrete analysis. What you're saying is the margin of appreciation actually has its place at that stage, not simply at the stage of implementation.
Exactly so. Exactly so. And of course, I'm sure both of us would recognise that sometimes the distinction between those two elements is ephemeral, yeah. But that they look at it on the basis of, do we need to go into this territory, and then are we going to leave you the various different ways in which you can do it? Are they looking at margin even at that earlier stage? The answer is plainly yes. See Rees. And see, just to trace it through very quickly, there should at the very back of this bundle be Sheffield and Horsham, which is, if only of interest because it shows the route of development towards Goodwin. It was the new tab, I think it was 59A. I don't know whether it's finally made its way into that bundle, but if it hasn't been put in there, perhaps it could be now. So that's 59A, so at the very back of, it'll put it entirely out of chronological order, but for present purposes, I just wanted paragraph 59. So the French case I keep referring to is B in France. It's referred to, it's really the first sentence of paragraph 59. Nor is the court persuaded the applicant's case histories demonstrate the failure of the authorities to recognise their new gender gives rise to a detriment of sufficient seriousness to override the state's margin of appreciation in this area. So essentially the history of this development in the case law was of transsexuals, for entirely understandable reasons, coming back to the European Court, each time saying effectively, well, we're suffering this particular prejudice and the consensus has moved on. But in Sheffield and Horsham they again said no, and they said no essentially for the reason set out in that first sentence of paragraph 59. And then they move in Goodwin, tab 32, if you go back. Tab 32, para 72, if you would. That's the well-known approach that we've seen. And if you go forward to 85, this I suspect is the paragraph that prompts my Lord Justice Henderson's question, because there are lots of adjectives and hard-edged questions being begged by the adjectives.
Yes.
But it's the final sentence which is of some interest perhaps, because you see the development that they treated as being key. So there's the development in the legal recognition of the new sexual identity of post-operative transsexuals, and you get the numbers. I was going to take it from the summary from the learned judge's judgment, but if you want the numbers that were before the court there, they're paragraphs 55 and 56. If you have the judgment to hand, we respectfully submit that paragraph 90 of the judge's judgment accurately sets out the extent of the consensus by then. That's what I meant by the example and the numbers. It doesn't give you an absolute guide, but it gives you some indication of what it took to move to a place where the margin was no longer good for the government in terms of resisting that sort of change. And if you're still in the judgment, that position led to the conclusion at paragraph 93 in the judgment in Goodwin, quoted in 93 of the judgment below. So you see how it's put there. Having regard to the above considerations, the court finds that the respondent government can no longer claim that the matter falls within the margin, save as regards the appropriate means of achieving recognition of the right protected under the Convention. So there you have the dichotomy, if you will, clearly reflected, going back to my Lord Justice Irwin's question.
Well, in the crudest way, once you've got a consensus, you've got to do something to recognise it.
And then you have a bit of another margin about whether or not you're taking particular steps or not.
And that will endure in a sense because there are such different legal systems and administrative systems in question.
Yeah.
Maybe not for this case, but in some cases.
Yeah, but there may well be minima. Once you've taken that first step, there may well be minima that have to be conformed to. But you still have something of a margin, and its breadth may narrow once you've taken the jump. But the reason for going in particular to this line of authority at this point is to demonstrate that it applies, if you will, at both stages, including to the prior and fundamental question.
Yeah.
And that line of thinking leads to and is supported by the alternatives that you find in para 67 of Hannah-Lynan. Just go, if you would, to tab 40 in the same bundle and go to Hannah-Lynan. I'm sure you've read 67 plenty enough times now, but it's the sentence that begins by the letter E, where, however, there is no consensus, that's where I got the word, within the member states of the Council of Europe, either as to the relative importance of the interest at stake or as to the best means of protecting it, particularly where the case raises sensitive moral or ethical issues, the margin will be wider. So you see the same thinking of those margin applying at the two stages, to the basic question and then to the manner of implementation.
And the same built-in imprecision of the terms which are being used.
That is true.
I mean, in the previous paragraph, we have a certain margin. What on earth does that mean, I might ask? It plainly means something, but immediately raises a question of...
Of what and how?
Yes.
But as I say, I think the best practical
Exactly,
answer,
is to
or
look
the
at
best
what-
assessment is
Yes.
look at the transsexual development, because there you actually have no, yes.
There must be between the last no and the yes,
Yes,
where
what?
the magic
Or
balance
something,
tips or whatever metaphor is looking for.
I don't put it entirely like that, because there will be other factors that
Sure.
play into it.
Yes.
Because there are three factors in play, as I outlined at the beginning. But in
Yes.
terms of consensus, if you just think about it in terms of only 4 out of the 37 didn't do the thing, didn't allow for recognition of status by changing of the passport. But then there were separate questions about implementation of that respect. Do you accord them full rights of marriage? Is civil partnership enough? All of that. And that perhaps takes one neatly on the same theme to the same-sex marriage cases. Again, a similar approach there. If you go back to tab 38 to Schalk and Kopf against Austria, you see the question arising for the court in the headnote. So the essential question that arose, as we'll see, is whether or not one needed either marriage or something equivalent to marriage earlier than the Austrian government actually introduced it. I think by the time of the hearing they had in fact introduced it, and the question was whether they should have done so earlier. For the state of consensus, see paragraphs 27 to 34. Again, it doesn't provide you with an absolute set of numbers or an absolute yardstick, but it gives you an indication. Yes. Let's have a look at 27 and 28. With the punchline in the final sentence of para 28. 19 is the number that allow one or the other. And 2 more on the way, see para 29.
variation on the theme, we now have vast majority.
Yes, exactly.
Vast majority consisting of a bare majority, actually.
Quite. I'm not sure, I've made the submissions, how much the adjectives help rather than the practical numbers. But you see that here we take the number as 19 for the sake of argument, or if you will, 21 because 2 are on the way.
Yep.
And then go forward to paragraph 90. So here the argument, there's an Article 12 argument about marriage, but the relevant Article 8 analysis occurs in the context of an 814 argument.
Yep.
So it casts as discrimination for that purpose, but that doesn't matter much. Look at 90. There's a question about whether or not that they address about whether or not in the context they were dealing with, it should be analysed as either or both of private life or family life, and they jumped for family life, perhaps understandably, even though they hadn't previously found that. See para 92. But then when you come to the analysis of the 19 number, or the analysis which is referable to the 19 number, look at 100 to start off with. This is the argument. They say they're discriminated against as a same-sex couple. First, they still didn't have access to marriage. We'll just park that for a moment. Secondly, in that no alternative means of legal recognition were available to them until the entry into force of the Registered Partnership Act. And it's that second one which is relevant. They analysed the first one in 101, but going to 102, turning to the second limb, namely the lack of alternative legal recognition. Court notes at the time when the applicants lodged their application, they did not have any possibility to have their relationship recognised under Austrian law. That situation obtained until 2010, when the Registered Partnership Act comes into force. And then 104, what remains to be examined in the second as the present case is whether the respondent state should have provided the applicants with an alternative means of legal recognition of their partnership any earlier than it did. And then you see the conclusion at 105.
Emerging consensus.
Well, yes, but look at the conclusion, and the adjectives and the variation they allow are still there. But the example is interesting because it's emerging consensus towards legal recognition of same-sex couples. Moreover, this tendency has developed rapidly over the past decade. Nevertheless, there is not yet a majority of states providing for legal recognition of same-sex couples. The area in question must therefore still be regarded as one of evolving rights, remember my phrase earlier, with no established consensus, if you want another adjective, where states must also enjoy a margin of appreciation in the timing of the introduction of legislative changes.
Yes, and there is perhaps an implication there that once you do get a simple majority of states, that might suffice. I mean, otherwise, why say there is not yet a majority?
Well, I suppose you could, but it's an example of a case where they were either just under or just over at the relevant time.
Yeah.
There's not much in it if it's 37 and 19. Anyway, but that wasn't enough.
Yeah.
So they say effectively even that won't do. So 19 won't do. Just give me one moment.
Paragraph 108 illustrates well the point we made earlier. Don't need to go into it, but states enjoy a certain margin of appreciation as the exact status conferred.
Yeah.
When one is
It
recognised.
goes to the status question, the broad status question. Sorry, I should have given you the reference on the same theme of same-sex marriage, consensus and so on in Hannah-Lyman at paragraphs 73 and 74. Again, just showing you the shape of this consensus analysis in a slightly different context. The numbers are sorry, and 75. Can I invite you to sideline 73, 74 and 75? Yes, I'm sorry, I'm very grateful to my junior for reminding me of 75, because 75 makes it explicit.
Now that it's gone quiet, Sir James, I've just been handed a note for everyone's information that tells me that accommodation have just told us that there may be noise disruption. Apparently there's a gas leak near Bell Yard, so...
I'm very grateful. Sounds as though they've sorted it.
It sounds like they're putting a last blast on it, doesn't it?
And last of all, everyone's evacuated. So 73, 74, and then the principled approach in 75 of Hannah Line and behind tab 40. And see in particular the final sentence on the point of my Lord Justice Irwin later. Give you a moment to look at those paragraphs. So 73, 74 and 75. So in those circumstances, we submit, going back to the judgment, that the judge's approach at paragraphs 110 and 112, noting the claimant's post-hearing note in 111 on the way through, but his approach in 110 and 112 they're careful paragraphs. Submit with respect that the learned judge's judgment is a thoughtful and careful judgment all the way through. If anything, 112 rather understates the significance of consensus to the analysis and to the margin. As one sees from the case law, it's often treated as the absolutely critical factor. In the state of that consensus, we cannot say that recognition, or whatever it may be, exceeds the state's margin. It's very often treated as being the key factor by the Strasbourg court in analysing that. And as I say, that's for all the good and principled reasons that I indicated earlier.
So James, if we look at paragraph 67,
Yes.
you've identified the three stages or the three ingredients. The third in your formulation being the impact on the individual. And in the very same paragraph where Hannah Line talks about consensus, you begin by talking about a particularly important facet of an individual's existence or identity
Yeah.
as something which restricts the mind appreciation. Now you haven't addressed that passage directly.
I'm coming to that now, right now.
Sorry, my fault.
The submission is going to be that the structure of that paragraph in the Grand Chamber judgment is of some importance. My Lord is entirely right that they do indeed identify that facet as being an important one, as we've, I hope, fairly acknowledged. But they then go on where, however, there is no consensus. That's the very next sentence, and they've structured it in that way.
So you say the consensus, as it were, trumps the individual significance of the point.
Yes, well,
trumps is perhaps not a very
Quite.
good word to use, but takes
These are
precedence.
all relative things, but they
Yes.
are acknowledging, and one sees it in application, in practical application in the case law.
Yes, and I noted that in your skeleton was wanting to know exactly where it was that you say the Strasbourg court vouches for that proposition, and you say the answer is here. In
I do, in terms of the structure of this. I'm going to come back to it. My learned friend yesterday took you to a French case in which a section of the court have turned round the order. You don't have it in quite the same way, but I'm going to make submissions about that in a moment, if I may.
Okay.
So turn to that point. We've dealt with the point that says it only really applies at the stage of implementation. No, it doesn't. It applies to the very basic question of status or recognition, as we've seen from all the case law. And my friend then says, well, the margin is narrow where a distinction is made on the grounds of a characteristic such as gender identity. That's essentially it. It goes to the point that we've just been talking about. And the first point in response to that submission is that it is clear that all of the cases in question consider gender identity and aspects of gender identity. And yet the analysis is plainly not simply, as it would be if that submission were right, the margin is narrow for that reason. Secondly, that this is, if not a trumping, a relative weight thing, is evident from paragraph 67 of Hammerleinen, which we've just looked at, where they start with it being a particularly important facet and so on. However, consensus. And it's unsurprising, I keep coming back to this principled point, but it's unsurprising that it's that they focus especially on consensus because of the very nature of imposing a positive obligation in circumstances such as this. If they find that a positive obligation exists, then that obligation exists immediately across all states in the Council of Europe. There can't be a difference. Any possibility of differentiating, whether in relation to the basic question or in relation to implementation, if things have solidified in relation to that, goes. And as we've seen from the case law, and as is evident from the repeated holding out against the thoroughly sound merits of transsexuals over the ages from the late 80s onwards, they approach this question very cautiously, no doubt for that reason. So my learned friend's reliance on AP and France, if I can take that, if you're in B still, it's tab 43, AP Gasson and Nico and France. And the key paragraph for present purposes is 121 and following, or the key paragraphs are 121 and following under the heading the margin of appreciation. But you'll see in particular in 121, see the final line and a bit, that all they're doing in 121 is to purport, as it were, to recite rather than to alter para 67 of Hammerleinen. I say they're not purporting to alter, nor could they, because Hammerleinen is Grand Chamber, and this is the fifth section, as you see from page 1604, first page of the law report. And we respectfully submit, therefore, that the guiding structure of the analysis and language is and is no more than 67. This doesn't purport to alter it. It's put in a slightly different order, so they lose some of the nuance of it, but it doesn't matter because they're not purporting to alter it. They're simply purporting to summarise it. And we see from the following paragraphs, my learned friend I think referred in particular to 123 and 122, that we would invite the court to read 122 to the end of 125, And whilst you're about it, and in order to get a proper context on this, can I also just invite you to flick an eye over 127 and 131. So the position in that case, once one actually understands the context of it, is that transsexuality had a consensus, if I can put it that way, and the question they were considering went to the preconditions imposed as to its demonstration. So you're a very, very long way down the consensus road already. This is 2017. And one saw Goodwin in 2002, as long ago as 2002, and the French system is still imposing this. It also involved a particularly concerning aspect of trying to demonstrate that, which is sterilisation. And the reason for inviting you to get a full context on that is because one sees, perhaps entirely understandably, that there was, as you saw from 124 to 125, real and clear consensus about that aspect, i.e. sterilisation, which was what was an issue. Virtually everybody in the world. And one also notes from 125, 127 and 131 that the court regarded this context as being at least mighty close to Article 3 for entirely understandable reasons. So all of that, we respectfully submit, leads to the proposition that one cannot extrapolate from this case any sort of general proposition, either because of the order in which they put the points of principle in 121, and the reason you can't do that is because they're simply purporting to summarise, not very accurately, para 67 of Hannah Leinen with its careful structure. But secondly, because of the very particular and disturbing context of that case, drifting on, if not over, the line demarked by Article 3. Still less can one develop any form of general proposition to the effect that you never have a wide margin in the field of these developing rights and acknowledgements, because that would be absolutely flat contrary to all of the case law I've taken you to. And the final point in relation to margin is that margin and the approach to margin in a case like the present, in a context like the present, in a context of the kind that one sees in the various cases that we've gone to, there is no different position if only you cast the claim as being 8 plus 14. Indeed, we saw in the Schalk case that it was indeed cast in that way, and the analysis was identical, and the consideration of margin was identical. And there's a jolly good reason for that, and the jolly good reason is that it would be wholly incoherent if the approach to margin were to be different. And that is particularly the position because in a context such as this, the courts are considering whether a positive obligation exists that may well entail a difference of treatment because someone is not being treated in a different way. But you still have essentially the same issues arising. Has the state of the consensus moved to a position of sufficient solidity? So that's the position on the international plane derived from the Strasbourg case law. There has been, as I know the court will be very well aware, for some time, and I think my lady, I might have made submissions on this in the last case I did in front of you, which was the post-Nicklinson affair, about the troubling assisted suicide issues. But as you're well aware, there is no mirror or no immediate mirror from the margin of appreciation concept in Strasbourg to the discretionary area of judgment if one wants to cast it in different language domestically. But the long and the short of it we submit is that for all the fact that sometimes the English courts have got to grasp that question and grapple with it, substantially identical themes affect the breadth of the margin and play into the question whether or not the courts are the appropriate people domestically to make the relevant societal judgments. That was the essence of the submission, if you recall, that I made in the post-Nicklinson case. But true it is that they come at it from a different angle, adoption and all that. But the themes and the echoes are very, very strong. I'm not going to develop the submission more than that. I just wanted to refer you to our skeleton at paragraph 30 for this purpose, and also to the interesting and helpful judgment of Mrs. Justice Leven, who was also in that case, I recall. So she should know, because we had the debate in a case now in her judicial capacity in H, bundle A2, tab 24, and the relevant paragraphs are 47.
Sorry,
Tab 24 in bundle A2, paragraphs 47 to 51. On this theme. I don't invite you to turn it up because it's on the general issue. But the basic punchline is, if there are controversial issues, socially, morally, ethically, and so on, the courts are very cautious before they intervene. And that is a strong message from Nicklinson, amongst others, once one has tried to understand what the various judgments mean and how they hang together, which was a challenge in its own right.
I remember the chart vividly.
Quite. But the one thing one can say with some confidence that they all agree that they shouldn't do it, or perhaps they shouldn't do it quite at that moment in history, with varying degrees of threat attached to it. But the point for present purposes is that the echoes are strong and come over. The second thing to bear in mind domestically is that there is, and again you'll be very well aware of this, there is a principle under the Human Rights Act, based on Uller and Lord Bingham in Uller all those years ago, which we respectfully submit hasn't been significantly or at all really watered down by the DSD decision, and Lord Kerr, bundle 2, para 19, Uller is in bundle 1, tab 2. So I don't invite you to go to those, it's just simply to note the basic principle that the courts are cautious in getting too far ahead or in getting ahead of the Strasbourg jurisprudence for all the reasons analysed in considerable detail in Uller, including that it's for the European Court to take the next step if you're in that turf. And it's one thing if you can be very confident that the Strasbourg Court would indeed take the step and all you're doing is a logically small thing from a base position which is clear. But the bigger the step, the more cautious you are, is essentially the...
Of course, one thing we can't do, unlike the other European court, is refer a question to it.
No, you can't. You can't, but that is one of the features that underpins the analysis in Uller,
Yes.
because applicants can go to Strasbourg from domestic disaster and the government can't. So if you take the step, it's likely to be a step in favour of claimants or applicants, as it were, and that does shut the route to, the government can't invite the court to refer a question to Strasbourg. That's one of the reasons that the principal position is as set out by Lord Bingham and Uller. So I was going to turn from the principles to the application of those principles to the present context, if I may, unless there's anything else the court wishes to deal with on the principles. So we're on application now, and the context is described in detail, unsurprisingly and carefully, in the judgment below. And the first of the factors, I'm going to take this factor by factor. You remember there were three of them. The first relates to consensus. Just to locate that in the skeleton, it's dealt with in our skeleton between paragraphs 21 and 26. The evidence of consensus as it was before the judge below was in Miss O'Neill's first statement behind tab 5 of the supplemental bundle, and she there set out the results of the survey that had been undertaken between paragraphs 37 and 55, so it's ON1, paragraphs 37 to 55. With particular focus on whether or not there was consensus supporting X on the passport in relation to non-binary or non-gendered people. And that was a specific and positive obligation asserted in relation to a specific cohort. And the question, as I put it earlier, is whether or not there is a consensus that that's in effect a necessary ingredient of affording respect. If it is, all states have got to do it. And in relation to the Council of Europe position, my submission is that whatever adjectives you apply, there is nothing like the sort of consensus that would be required amongst contracting states, either about the basic question of legal recognition of the status of non-binary people, or specifically about X on the passport. And we set out the position in our skeleton at paragraph 23. At the time of the judgment, only 2 states in the Council of Europe, remember 19 wasn't enough in Schalke, only 2 permitted an X marker on passports at the time of the judgment. That was Denmark and Malta. None recognise non-binary status in law more generally, although of course we acknowledge that there have been some developments since then, which we summarise in our skeleton at paragraph 23 sub 2. But quite where and how far even those developments go remains to be seen. Sometimes you've got a strong judgment in relation to intersex people. Sometimes you've got a judgment from a court which has yet to be translated into a legislative solution, so there's a question about how far they will go. But of course we recognise that there have been some developments, but even if you said, well, anyone who's developed in that way or whose courts have reached a judgment of that kind can be put into the consensus pot, you're still a very long way short, we respectfully say.
James, both the appellant and the intervener really speak more of a trend.
They do. They do. And
maybe a strong trend, but and rapidly developing trend, but that's the way it's broadly put.
that is the way it's put, and they put it, as one would expect, very fairly in that respect, and I suspect there's not much difference between us on that. Plainly there have been some developments, and there are developments more recently. I certainly wouldn't seek to deny that. But the comparator that you're really trying to do at this stage in history, and this is all about at this stage in history, the comparison you're really doing is between the position where we are now, taking it at its highest, and of course we bear in mind that this is an appeal from a judgment at a particular point in time, and the question is whether the judge was right or wrong, but the comparison you're really doing is between the situation as it is here and the situation which persuaded the Strasbourg court or didn't persuade the Strasbourg court, in their language, that the margin of appreciation had been exceeded and was no longer available. And if one looks for the best guides in relation to that, by the time you get to Goodwin, only 4 out of the 37 are not doing the basic thing. When one looks at Schalke with their particular feature of marriage or equivalent recognition in terms of civil registration of same-sex partnerships, you've got 19, but even that do.
And what you say is the fact that the direction of travel is pretty obvious is not sufficient.
Not sufficient for the present.
No.
And to some extent it ties into coherence and continuing to review and all of that, but not sufficient for the present. And if one said, at the point, in fairness to the learned judge, if one said at the time he was considering the matter, well, you've got two in the Council of Europe.
Yes, and I think you would accept this, indeed you would say this positively. This is an appeal from a case that was heard 18 months ago. We've quite rightly been informed of developments over the intervening period, but presumably, I mean, we have to really look back at the position as it was. Then, unless we can detect some error of approach, in which case we would be free to look at the matter again ourselves. But
Well, we always
absent such an error.
My lord, of course, and the implication that you're trying to do it as it today always flows from updating evidence and information that's placed before the
That's
court.
why it can be dangerous.
Right,
Yes.
but when you've been shouted at as often as I have by Lord Justice Singh in particular about breaches of candour,
Yes.
one becomes a little nervous about not updating whenever humanly possible. but you're right, my submission is this is an appeal, and the question is whether the judge was wrong. That's well-established jurisprudence. But those points of comparison, as I say, even if one acknowledges a trend, acknowledges that it continues, and acknowledges that, for present purposes, even if one says, well, put in everyone, as of today, you still wouldn't be surmounting the sorts of consensus, albeit there aren't any hard-edged rules on that. The indications from the actual approach to this issue in the Strasbourg court is tolerably clear, and is tolerably clear for the good principled reasons that I won't go back over. I think in relation to Council of Europe, the only other point to mention is that there was some reliance placed both in my learned friend's submissions and below on the Parliamentary Assembly resolution, which one very regularly has. The position in relation to that is that they are advisory only, they have no status in international law. True it is that sometimes in the court's judgments they do refer to them, but for present purposes, perhaps the really significant point is that after that Parliamentary Assembly resolution, there were still no, as it were, immediate changes or movement in the consensus.
For any of the reported cases following that, I haven't done that exercise.
Don't know.
Any of
Can
the
I?
application of Hammerlion come after that resolution?
Can't remember. Can we check?
Yeah, don't distract yourself.
Yeah, I'll find the answer first. So that's the Council of Europe position, and that's obviously the key focus so far as Strasbourg is concerned. But they do sometimes take into account, as we saw from Goodwin, the international position more broadly. But of course it comes with the note of caution that the ECHR is a European instrument, and its foundation is treaty obligations voluntarily assumed by those who contract to it. So although of course it's right that there's plenty of Strasbourg case law that takes into account international developments more broadly, we recall the French case that we looked at with all those UN bodies all lining up against sterilisation, unsurprisingly, in the case of the cohort in question in that case. But the international picture is essentially the same, although perhaps even less of a trend there, but certainly nothing like the sort of consensus that would persuade the Strasbourg court to move, we submit. Nepal, Australia, New Zealand, Pakistan, Canada, some states in America, and possibly Uruguay. But again, not all of those, if any, are really truly focusing on the issue that confronts us. One can take that, for example, I don't invite you to go back to it, but you were taken yesterday, I think, by Ms. Carl's Frist to the Inter-American Court decision in the International Materials Bundle at tab 4. But one needs to be very clear about the actual issue being addressed in those cases, and in that sort of case, and as far as we're aware, none of the parties to the Inter-American Convention, with the possible exception of Uruguay, allow X on the passport. respectfully submit that here the international picture adds very little, if anything, to the drive, or the lack of drive, that one gets from the position when analysing it within the Council of Europe. And so the conclusion we submit is that this is a key factor. The UK is entitled for the time being, and I emphasise for the time being, because no doubt the thing will develop as it did in relation to transgender, transsexual people in the case law you've seen. The UK is entitled for the time being, pursuant to the margin created, in part and in large part by the lack of consensus, to maintain systems and to maintain the position as it is. And we emphasise that if that is not so, and if the positive obligation exists to, for example, respect status, or specifically to put X on the passport to allow for that feature, if that is a positive obligation already and now inherent in the ECHR system, then it follows from the lack of consensus that many states in the Council of Europe are in breach. Yes, I'm very grateful. So, the Parliamentary Assembly,
Yep.
31.3.10 is the date of it, and it was referred to in Hannah Linen at paragraph 56 when reporting the third party submissions in Hannah Linen, but is not referred to in the analysis of the Grand Chamber. So it's referred to in recording the submissions of the third party.
It was before the court.
It was before.
Was it before the court?
Yeah, but they refer to it in summarising the, no doubt the third party relied upon it, but it didn't then transmogrify into the analysis that the court did. Thank you.
Thank you very much.
Thank you very much. So going back to the judge's judgment, we submit that he accurately summarised the position, I don't think anyone suggests otherwise, at 127, and he reached accurate conclusions at 128, and in the second half of 129, all on consensus. So accurate findings of fact at 127, accurate conclusions at 128 and the second half of 129. I'm going to turn to the second of the factors, which is the state and its systems.
Yes.
Factors that concern the state and its systems, dealt with in our skeleton at paragraphs 13 to 20. And my first submission is that there is a proper and properly recognised need for coherence of any change across government and in the law. There is, of course, no direct analogy with the position in relation to birth registration schemes, but we don't rely upon the cases that we cite for that purpose in the domestic arena, including in particular the recent decision in TT of the President of the Family Division, bundle A2 tab 25. I don't invite you to turn it up, it's para 271. We rely upon it for the broad and entirely, if I may say so with respect, obvious proposition that, as the President put it there is an importance to society in general of having a coherent scheme of that kind.
That's all you rely on that case for?
Exactly so.
I mean, it's the appeal in that matter is listed.
Yeah. Listed before the Court of Appeal. I hadn't realised that, but nothing I think is going to turn on whether he was right or wrong on the original conclusion. It's just for that self-evident broad proposition. And my submission is, in broad terms, that's the first submission you need, and it's perfectly acceptable to have, coherence and coherent thinking. And the judge is the broad submission correctly analysed the importance of coherence between 117 and 121, and those paragraphs are key and central to the government and are correct, we submit. The question, let's be clear, is whether or not the government is obliged to make the change in isolation. That's the positive obligation question. Or, to put the alternative, whether the state is entitled to take the view that if a change is to be made, it should be made coherently and either across the board, by which I mean all things flowing from recognition of status and so on, birth certificates and everything else, or if not across the board, at least when those issues have been properly considered across the board.
So James, I'm sorry to break in again, but if you were to lose on consensus, what good would any of this be to you? Would you really be justified in saying, well, we need to do nothing because we can't do everything?
Well, I think at that stage the argument would have to be different. I quite see why my lord asks it. If the consensus goes against, as it were, if you're already outside, then the only margin that would be left would be as to manner of implementation. And I might be able to say in those circumstances, I'm still allowed a short period of time, as it were, in order to assess how the thing should be done, rather than, as it were, introducing something in the left-hand corner of the kingdom without having thought about whether or not the right-hand corner ought to react to.
Against you. Well, all you need to do here is to change this bit, and that's not going to disturb whether you have recognition of non-binary gender status in other documents and other systems.
The force for that case would be a great deal stronger, I respectfully accept, if I've lost on consensus. Because then, as it were, you're in the territory of being only concerned with considerations of implementation. I've still got a margin in relation to that, but if it can then be said, well, technically you can do it here without having to necessarily do it there, whereas the submission I'm now on is about entitlement to consider things in the round. I would probably still be making something like this submission, but I would expect to be squeezed.
Because then you'd have the state of affairs where, as you put it, the bottom left-hand corner could be amended through Crown prerogative, leaving you as much time as you like, subject to any other challenge, to think about how you are going to address the whole non-binary third gender issue.
Yes. One can approach the same question in a slightly different way, which is that normally the breach in the walls of the city in all of these cases is created by the consensus having moved in favour of recognition of status and all things that flow from that. So it's normally been about birth certificates and those things which are the moniker of status. The irony perhaps in this case, which was now that you see running through the judgment, is that they haven't gone for that, even though the logic of it is there, and they've gone for the lesser beast, as it were, which is the passport. But I entirely accept that.
I don't think you should necessarily draw adverse inferences from that. I mean, there has a sort of slight feeling of that there's a sort of pejorative view, or that was in some way tactical and to be deprecated, that they made that choice. And is that your position?
My lady, I don't deprecate anyone for running any case they want to in any circumstances, but the logic of a position taken must be recognised. And this is really the point I'm on, the question of entitlement to take a broader and coherent look at these things.
Well, I mean, there may be a fortuitous element in the fact that this change, if it is to be made, can be done relatively simply because it doesn't require legislation, and at relatively little cost. £2 million is pretty small change in the wider scheme of things, and without necessarily having wider implications. I mean, that's really where you begin if we get to the stage of the analysis. because it is a pure non-committal X, which in itself has international recognition going back to 1945 as a possibility in the area of international air travel.
Oh, yes, but the submission that I make is that it has significance once you take the first step.
Well, I know you're trying to frighten us, you know, like all good advocates, with a sort of, this is the domino which will start off the chain reaction.
Well, it's not an inter orum submission, it's the recognition of the reality.
Yes, well, I mean,
Which is at the moment you do take the first step, you automatically create, amongst other things, you create an Article 14 target, and you create a justification target. I'll come to develop the submission,
Yes,
but all the points you made yesterday about my learned friend was strongly agreeing with about the significance and importance of the passport serve to underline precisely that point.
Yeah.
Why, if you've got a change to the passport of this kind and it's driven in this way, because this would be the driver for it, what's the justification now for not changing the other things?
It really would be the wedge in the door, to use another metaphor.
And of course you can characterise it as an inter orum submission, but it genuinely is a reflection of the reality of how this situation works.
So you would say that I'd be wrong in saying that would then leave the government as much time as they like to think about the whole much more complicated, it would be said on the appellant's part, situation, because you'd say, no, that would last about 10 seconds, because the very fact of doing it leads straight into other challenges.
Yeah, and the fact that you call it indeterminate begs the question as to what criteria, whether there are any criteria and all of that. And this would plainly be a change which would be driven by this. And what the court is being invited to do is to say there is currently, as of today, a positive obligation, brackets in the UK and elsewhere across Europe, although of course you have no jurisdiction there, to make that change to the passport, to allow that to be introduced. But the question I'm on now is whether or not the state is entitled to take the view that if a change is to be made, it should be made after that sort of coherent consideration. And my submission is that, having regard to the scheme of administration and the law as a whole, the state is perfectly entitled to say, well, we're not going to do it just in relation to the passport in isolation. The coherence of a system for recognition of gender identity is a legitimate aim. See the cases at Skeleton Para 14. It is clear that legislation would need at the very least to be considered, and the government is entitled to consider the broader picture. We've set that out in some detail in Para 16 of the Skeleton, including at least some of the myriad ways in which English law is currently premised on that male-female divide, the NF divide. See Para 16, Roman 1, the scale of the change, see Para 16, Roman 2 and 3, and it isn't just a thing that could be done with relatively greater ease and cost, because there are a highly significant set of linked social, administrative and legal issues. So my submission is that the government is plainly entitled to take the view that the change needed to be considered carefully as part of the overall coherence of the scheme.
James, could I? Sorry,
I'm sorry.
I don't want to stop
No.
developing that, but in general terms, I speak for myself. I could see the attraction of the argument that you've got a fundamental problem of recognition. If the government is to deal with it, it's going to resonate in all sorts of areas, birth certificates, marriage, all the rest of it. But there are only two possible changes in relation to the passport. Either you have an X, or you don't have gender markings. Whatever solution the government came up with at the end of more time, more consideration, less distraction from Brexit or whatever, the government will only be able to choose one of those two outcomes in relation to the passport. And it won't effectively be able to choose no gender marking until the ICAO requirements are altered. That's a global consensus. So whatever engagement,
It's
whatever...
a global consensus that permits. So states are permitted to have X on the passport. There is no requirement for...
Yes. But the choice is, in theory or hypothetically,
The choice is maintain the current position.
maintain the current position, do nothing, X, or theoretically, no gender marking at all.
Yeah.
You can't achieve the last without changing the ICAO rules. So any
Hang on, you can't
achieve
remove.
no gender marking because the ICAO stipulates there will be a gender marking. It can be X or it can be M or N. So the end point of a process that takes place within government, across government, over the next year, 5 years, 10 years, is going to end up with a narrow choice about the passport. Do we or don't we introduce X? That's it.
Depending on how ICAO develops, and that choice is still there. MF versus X.
So, in what way will the government, following the trend, if not the consensus, to look at recognition, end up being stymied, to use a fashionable word in the legal context, stymied, because either it's going to choose to have an X or it isn't.
I'm not sure it's going to be stymied, but it's got to make that choice. And in making that choice, it's got to understand the ramifications of the move from the current position to the alternative that you outline. Let's assume the ICAO position remains unchanged.
Yeah.
You've still got that choice, and that choice is one that has to be considered. We respectfully submit, and can be considered and should be considered in the light of all the consequences that would flow from that more broadly. That's the point I'm on. The question is, are they entitled to say, if we're going to make that change to move to X here, and of course there are plenty of questions that are begged anyway about whether or not it's a genuine choice, X, or whether or not there are criteria for X. So that's a big old question as well.
But are neutral about that, aren't they? They say, of course, you may cover that in different ways. You may.
They may be neutral about it, but the difficulty is that we've got to think about that. We've got to think about that because it may make quite a bit of difference. If it's just a purely voluntary thing and anyone could do it, the long and the short of it is that is the same as removing the sex marker on one view. Because anyone can do it. It's just a free-for-all. Whereas if you introduce criteria, it then becomes apparent that you've got a driver for it because the criteria is e.g. non-gendered or non-binary, at which point you create the precedent and you create the target and you create the ramifications.
So, in essence, your response to my challenge is, it's not a simple binary choice, X or no X. It's the way you do it, the criteria you employ to do it, how you do it, may have really serious implications.
That's one part of the answer, but my fundamental answer to my lord is that you posit a choice, and we agree. The choice is between maintaining MF and introduction of X in whatever form, and that choice is one we are entitled to consider as part of a coherent overall change that might otherwise be introduced. And it needs to be considered in that way because it does have ramifications. Of course, almost any submission I've ever made in the last 10 years could be characterised as an in terrorem submission. But it is about recognising the consequences. What happens next? And forget about the difficulties that the government might be in because the discrimination case comes the day after you make the first change. And someone then says, well, you can't, what's the justification now on birth certificates? Yeah. Well, why is it different? It was being submitted to the Court of Appeal that passports were used, and we agree, very frequently, because people have lost their birth certificates. We all have. And passports are used as the moniker of identity very regularly. Well, if that's the position, what's the justification for not changing the birth certificate? It's incoherent. So you create a target, but as importantly, the government, and that includes Parliament for present purposes, is, we respectfully submit, entitled to decide that it's not going to make a change just because it can, and just because it can without ramification as a matter of law or automatic legal consequence. It is entitled to take the broader view that says, well, if we're going to do this, we would like to do it as part of the full-blown consideration as to whether or not we should go further, whether or not there should be full-blown recognition of status of intersex, of non-gendered. There are a raft of issues that arise in relation to gender identity more generally. At the moment, the legislative scheme is narrow. The consequence of Goodwin was a very specifically targeted act dealing with only one cohort. And you see from the GEO analysis, which is, again, I respectfully submit, thoughtful and sympathetic, you see that they are concerned to be looking at these issues more broadly, not merely in relation to the position of these, of this claimant and those in the same or similar cohort, but in relation to others which may be comparable. So I can entirely accept my Lord's binary choice. If I'm allowed to put it in that way.
Phrase will not be taken.
Quite.
But, so it's not, what you say is it's not a binary choice, even though it is a binary choice in its end, but how you get there, what is placed around it, the criteria for it are all intrinsic to the...
All intrinsic to it, and even if it were just a binary choice, we would still be entitled to look at the ramifications.
Setting aside the legal risk of the discrimination claim or other action, the two are intertwined. That's
Exactly. And the reason we put it that way is because, well, I mean, two reasons will probably suffice for present purposes, but one, there are real and proper constitutional sensitivities about a change in the left-hand corner of the kingdom which has policy and legal implications across government and for other pieces of the law. And I'm going to come back to that because there is a question about constitutional propriety here. Is it for the courts to be doing that? Is it for Parliament to be thinking about those issues? All of that. But secondly, straying closer to inter rorem, if you move in one area, you create the comparator target. You create the justification dilemma. And you do need, in policy terms, you are entitled in policy terms to think through the changes and where the logic of one change might lead. That's not just an inter rorem thing, because you risk being sued later on. It's a proper policy formulation thing.
I didn't mean to suggest that inter rorem arguments are necessarily ill-founded. It's just it's a question perhaps of probing the legitimacy, because
Quite.
it's a kind of argument is easier to make,
Yes.
and governments are perhaps rather, for understandable reasons, prone to make, which again is not to say that sometimes, indeed maybe quite often, there is real force in them, but we do need to be sure that this is a case of real fears and not sort of...
But it's not just real fears, it is in part real fears, but it's also the desire coherently to address deep and difficult social issues without just, as it were, being
Yes.
rammed into one solution.
Yes, and I suppose that perhaps is why it's so important, you would say, to understand that Goodwin, although very important in its narrow way, was in fact a self-contained issue, because it really only dealt with transitioning from one long recognised gender to the other, and vice versa.
It did, and one sees that reflected in the solution that was put in place in consequence of it.
Indeed, whereas superficially it may be said, well, here we have a low-hanging fruit that can be plucked in a similar way, so to speak, and which won't have wider implications. And I think you're trying to persuade us that that is too simplistic an approach.
I am. And the only reason I'm sensitive about inter rorem arguments is because they're normally characterised in any judgment which is handed down as a thing devoutly to be avoided.
Yes.
And I have a stinging memory of Lord Reed at one point comparing me to the fat boy from Pickwick Papers, who then tried to frighten the life out of the court, unsuccessfully as it appeared in that case, or Lord Steyne describing arguments as consequentialist arguments of an alarmist nature before dismissing them out of hand. So, but my Lord is right. And the too simplistic point we do submit, and this perhaps gives it a little bit of flavour, is all the more so when the foundation for the case, for the narrow change in the left-hand corner of the kingdom, is based squarely on a much more general principle. The driver which is presented to you for this change is based absolutely squarely on broad notions of respect for gender identity. So what my learned friends do is to saddle up to the engine, which is that general engine, and then say, but you can contain it when it starts moving, only to make that change. And the point is perhaps as clearly made as anything by reference to the submissions that you heard yesterday from Miss Cars-Frisk. She placed considerable reliance, if you recall, on those Yoga Carter, if I've got the Yoga Carter principles, the plus 31 she took you to specifically. But look at its breadth. Look at the breadth of that principle. That could be deployed and would be deployed in support of a total change to status. Birth certificates and all the rest of it. We would note in addition, in relation to the Yoga Carter principles, before one goes too far down that road, that although the committee of experts was indeed eminent, as far as we can tell, those principles have never been relied upon by the European Court of Human Rights, save for the dissenting judgment in Hämäläinen. See para 15 on page 85 of that report. And it might be thought that that's somewhat surprising given their age. They were drafted in 2007 and 2017.
So James, none of that can be taken under my diminish the importance of the issue to this appellant.
I certainly don't seek to do that.
Well, one has to be careful to make that explicit,
Yeah.
because one can see that gender identity, particularly when it is struggled for, chosen and struggled for and achieved, must be absolutely central to the individual's identity.
My Lord, I'm going to come to the impact on the individual as a third of the factors. So I'm going to come to that directly. But yes. We've quoted in our skeleton. I don't invite you to go back to it now, but you'll recall that we've quoted the Bellinger case, and in particular Lord Nichols, for the proposition that if there are a variety of ways in which you can deal with issues, including preconditions to recognition and all the rest of it, they should be considered as a coherent whole. And again, we rely upon that quotation for the general proposition, rather than any direct analogy with the particular facts and circumstances there.
Paragraph, it's 17, I think.
Yeah, it's 17, but it's paras 39 to 45 in Bellinger, which is bundle 1, tab 1, if you want it in the raw. I think we've quoted from only one of those paragraphs. So my learned friend Miss Gallifant says, first of all, that this that the analysis implies that you can't have a coherence justification in effect unless it is shown, or you can't have one of any weight, unless it is shown that doing the thing, the subject of the positive obligation, here X on the passport, would inevitably and necessarily lead to consequential change. And that, we submit, is wrong. Of course, as a matter of law, it could be done without, as a matter of law, having consequential and direct effects. But that is not a requirement of a proportionate and proper state decision made under the ECHR system. Judgments are to be made and can be made about making changes in a coherent manner and considering change on that basis. And the ECHR analysis nowhere in the case law effectively says, well, you as a claimant can pick the change that you wish and then insist on that change and its consideration being thought about in isolation. So then my learned friend says, secondly, that there is no necessary recognition of third gender, to use the shorthand. X is neutral. And so you could change with impunity and with no wider ramifications. So she says there is no force to the need for coherent consideration and change. And my submission is that that is unrealistic and selective as a submission. And I make 5 points in answer to it. First, the entire driver for the change in the context of passport is said to be the importance of that third gender. There's no policy driver or reason to change it otherwise. Second, criteria would inevitably include acceptable bases for ticking X, and would probably thus need to identify non-gendered, non-binary, intersex, or whatever. And so that would then raise broader questions. That's the most likely outcome, because there would be some restriction, some criteria, and the moment you do that, it becomes obvious you've created the target, as it were. Third, if there are no criteria and it's just a matter of choice, what then? Well, then there is a disconnect to gender identity, which is said to drive the need for change. That would then in effect render sex marking on passports optional or voluntary, and that does take one then into security concerns, greater security concerns about using sex as a check and so on. And there is, if this is the position, no criteria and just a choice, there's a less powerful case for the driver for a positive obligation, not recognising non-binary as a status for this purpose, simply avoiding the need to select from too narrow a menu by rendering it in effect optional. Fourth, a friend can't have it all ways. She positively advocates the passport's use and seriousness, and the seriousness of and regularity of use as a document for identification purposes, entirely understandably. But that precisely raises broader issues. What is, and they're obviously linked back to how you do it, whether there are criteria and so on, but what is to be made of it in this way if this change is made? Is it a change in status in all but name? What ramifications would that change have? It's almost impossible to see, given the entirely understandable exchanges about the frequency of use of passport for this purpose, to see what would need to be and what should be considered alongside those issues in relation to changes more generally in status. What would be the defence, for example, to the challenge coming the next day after the change to, well, why haven't you changed the position in relation to birth certificates and status more generally? And those are serious issues, and they should be considered as such. The fifth point is linked, which is that there is a target created for the next challenge. The taking of that step from which it is difficult or impossible to retreat in other areas. See the question asked by my Lord Justice Irwin yesterday. If the passport changes, was the question to my learned friend, there would still be no fair balance. And the answer should be yes, on the logic of my learned friend's case, and moreover, much more difficult to meet the consequences. So you do carefully need to consider, we respectfully submit, that first step. The point was then made that most trans people do not have certificates, but the system nevertheless allows them to change the sex marking on the passport, and so already tolerates incoherence, if you will. I confess I don't recall the judge being taxed with that point, and it doesn't appear to be reflected in the skeleton, but my fundamental submission is it doesn't take her very far anyway. Those changes are made within the existing MF system and simply relate to ways of achieving by another route that which the law permits anyway, through the certificate process and all the rest of it. But if anything, and if there is incoherence, which is the premise for this submission against me, that reinforces the need to consider matters across the board. All the more so if the passport is accepted as being an important document reflecting status and in broad use in the real world for identification and other purposes. So we do respectfully submit on the basis of all of that, that the judge was correct in paragraph 130 to put the matter as he did and to accept the position that these issues should be considered in the round and coherently. Paragraph 130 is really the summation paragraph, the conclusion paragraph. And you'll note how he then treated the next topic, which I'm going to move to very briefly, which is security. In essence, at 130, he's treating that as one of the factors that feeds into the need to have coherent consideration of all of these changes. That's the essence of his 130 analysis. And you'll appreciate that there are two ways in which the Secretary of State relied on security justification. And that is firstly that it's relevant to preventing fraud when issuing a passport, and secondly relevant to identification of travellers at the borders. And on point one, it's just about minimising opportunities to commit fraud. That's in essence the nature of the concern. That was evidenced in, if I can just give you the references without going back to them, because I think the learned judge picked them up, Mr. Woodhouse's statement at paragraph 28, supplemental bundle tab 5, the internal review, supplemental bundle tab 16, at section 3.
Sorry, tab number?
Tab number 16, page 179, showing that one aspect of fraud prevention is seeing whether the gender shown on the form matches the gender on supplied documents, previous passport and apparent gender shown on the photograph. The ICAO survey, section 5, in supplementary bundle tab 5, page 70E, in effect the last paragraph under the heading identification issues. That makes the point that not having a gender field would allow the use of the document by someone who presented as male or female and regardless of their name. But true it is that that was considering the question of removing sex markers altogether. There's force in my learned friend's point in relation to that. But the issue is perhaps not as discrete, or nearly as discrete as she made out, for a reason I've already touched on, which is that it all rather depends on the criteria or absence of criteria for being able to access the X marker. If it's just a matter of pure voluntary choice, you come very close to MF being undermined in practical terms, and so all of those considerations of removal apply in substance, and all the points apply in substance. We've given you an authority, I don't need to go back to it, of the Supreme Court themselves, Lady Hale again being concerned about there being a particular risk of identity fraud and theft and so on in relation to trans people. But that's a broader recognition of the sort of points that we have here. And the risk is enhanced in respect of X markers we submit for two reasons. The first is that fraudsters may obtain a passport in the birth gender of a person with an X marker. And the second is that fraudsters may apply for a passport with an X marker, and HMPO then has difficulty or can't cross-check gender identity with the MF indicators on a birth certificate or on the other evidence provided. So that point highlights rather the need for coherence in consideration. It's at a security level particularly problematic if you allow, and the risk is greater if you allow the exchange on the passport, but you then don't have, as it were, concurrent and coincident changes to underlying documentation such as birth certificates, which may be regularly used for cross-checking purposes. You create that difficulty, so it's an aspect of coherence.
Is there any evidence from any of the countries that have, I appreciate some of them with a short time, it'd be too short to get any evidence, but Australia's had the X marker for since 2005. As far as I could see, there wasn't any evidence of security problems actually documented.
Well, Lord, I'm not aware of any. My short answer to the underlying point my Lord is putting to me is that there are, as you rightly indicate, it's a relatively recent thing, it's a very small number of countries, and even if there were no evidence at all of any difficulties there, that would simply indicate that those countries have decided to take greater risks, as it were. All we're seeking to do here, and I don't want to overstate it, all we're seeking to do here is to identify some security concerns. My principal case, as you understand, is on coherence. And the same point, in essence, can be made in relation to the second of my areas, which is checking at the border. And my Lord could equally well say to me, well, where's the evidence that people who have X on their passports coming from Australia are here? And again, I can point, there isn't any, as far as I'm aware, evidence of that turning out to be problematic, even though there are there, but it'll be a very small number of people, it's a small number of countries, and the security concerns have been raised and are real. The only judge correctly accepted in paragraph 118 that they were there. As you see, the punchline in the judgment, again adopting his cautious approach, was to feed them in 130 into the coherence consideration, the need for coherent consideration, thinking about these things in the round. And I've given you one example of that, where if you don't alter the underlying documents against which you check, you create that dissonance, which is potentially problematic. I was just going to give you the reference to the second of the ways in which that is put, which was relevant to identification of travellers at borders. That's dealt with in Woodhouse at paragraph 29, supplemental bundle, tab 5. In the internal review at paragraph 5.4, tab 16 of the supplemental bundle. And section 5 of the ICAO survey, tab 5 of the supplemental bundle, at section 5. So if you change the system, effectively you lose that advantage, that protection, unless and until there are further changes to the ability to cross-check across consistent records. My learned friend's criticism, or one of her key criticisms in this respect, was that none of the work on the subsequent ICAO survey has gone anywhere, and the position on the evidence is, as stated in the paragraph my Lord drew attention to in the updating evidence, that there's nothing to indicate that that work has been taken forward. We've been trying to ascertain what the position there is. My understanding, but I'm going to try and get confirmation, is that a similarly small group of countries responded to that second go in October 17. I think there might even be 21 and 21, which sounds very coincidental, which is why I asked for them to check it. But it may be coincidental because, but also right, because the same people were interested in responding to that. But there were concerns, as you saw from the initial survey, about how useful that small number of returns actually was in trying to divine anything really useful. So it may be in part that that's the explanation, but I'll check and see if I can get greater clarity in relation to that. As I say, I can't point to anything that is the result of that survey and that materially assists in this respect. So that's how we put the security case, and I've given you the relevant paragraphs from the judge's judgment on that, principally 118 and 130. Thirdly then, the factors that concern the individual. This is the third of the headings, dealt with in our skeleton at paragraphs 9 to 12. And just to make it clear, I hope I flagged this already, but we do not say, we don't need to say, that gender identity is not an aspect of private life. Or still less, that such identity falls outside the scope of Article 8 entirely. The submission, rather, is that we are here dealing with recognition or not of a positive obligation whether you restrict it to a passport change or you run it more broadly as a necessary positive obligation to respect status of non-gendered or non-binary people, which all contracting states would therefore be in breach of today, and that's a much more controversial issue and framework on which there is, as I've indicated, nothing like the sort of solidified consensus. And where the analysis of the factors in play, these three factors, may very well be different. And the overall balance, therefore, may be very different. So it's that, the first point is really that identification of the correct issue that frames this. The second point is that none of the cases concerning gender identity in Strasbourg have involved non-gendered or non-binary status and a claim for recognition or indeed a specific positive obligation to give effect to particular legal repercussions flowing from that recognition. And my submission therefore is that you can't simply jump from statements about gender identity in a male-female case or a transsexual case of that kind to an assumption or a conclusion that they apply automatically to non-gender. So when, and this is the limited point that we make, so when in, for example, the Van Cook case, bundle B, tab 33, that the court states that gender identity is one of the most intimate aspects of a person's identity, you do need to bear in mind that that concerned a trans woman seeking to be recognised in the opposite gender and is dealing specifically with the rights of transsexuals. It is another step and another conclusion and another consensus when you are considering the raft of issues that relate to non-gender as a status and to the legal and practical consequences of that. There are real societal and legal differences in recognising a trans person in an existing gender to recognising a person as not having a gender at all. And there are difficult, far-reaching social questions that flow in the non-gendered situation. We've given examples in our skeleton at paragraph 16. How to address non-binary parents, prisoners, school pupils, patients in hospitals, and so on. You can't therefore just jump from a read across to non-binary. or to an assumption, if you will, that the three factors will operate in the same way in relation to non-binary people. So the short point is that there isn't any case in Strasbourg on non-gender, and that given the conceptual difference between recognising a trans person in an existing gender role and recognising a third category altogether, it shouldn't be assumed that the European Court referred to a gender identity in cases like Van Cook and Goodwin with the necessary correlation that the same consequences and need for recognition flow. In terms of
that formulation in Van Cook has, I think we were shown yesterday, been repeated in quite a number of subsequent cases without any toning down or narrowing of the language. So the more one sees it repeated as a general proposition, does it not to an extent acquire a life of its own as a statement which one should interpret without too much reference to the particular context in which it was first made?
My lord, yes, and I hope I've fairly accepted that gender identity is plainly recognised in a broad sense as an important thing. My plea is for some caution before jumping from that forwards, as it were. You still have to apply the three factors. You have to recognise, no doubt, that these are aspects, perhaps important aspects of a person's private life. But there is still a different state of development, there is still a different consensus, there are still different issues that need to be thought through. And as I say, our coherence case, as you well appreciate now, is not based on not necessarily based on never, it's based on yet.
Yes, I was really just wondering how high it is you put this particular submission. I mean, I don't think you're really submitting to us that we simply shouldn't go anywhere near, as it were, the detail of this case, simply because Article 8 has not yet been held by the Strasbourg Court to extend to non-gender people.
I'm not submitting that, and that's the reason I'm trying to analyse the three factors, as it were.
Yeah.
As if we're in the game. I've taken no issue with the engagement analysis, apart from the formal one. It all feeds into this third factor. But I'm taking no issue with that analysis in substance of the learned judge. And the position at the moment is that there is no discordance, we submit, between social reality and law, if one wants to analyse it in those terms. Across the piece in the United Kingdom, including in relation to passports, two genders only are recognised, reflected in the Passport MF moniker. The court in Goodwin was indeed struck, as my learned friend correctly pointed out, by the provision of surgery for the applicant by the NHS and then not providing for legal recognition of the steps taken at 78. But again, one needs to be cautious before jumping too far and too readily over that transition, as it were, in the context of transsexuals might be thought to be different, at least, to the position here. And in any event, it was just one factor weighed in the balance in the applicant's favour. And all the other factors were then considered in Goodwin and had moved, including, for example, consensus. And it would be a pretty unattractive position if it might be thought, if a state were to be hanged in the court for having properly not, as it were, declined to exercise that sort of procedure, if it was sought in a context such as the present. So we respectfully submit that position is not directly to be transposed into ours as a strong factor against, or as demonstrating a discordance between social reality and law. So far as the impact on the claimants is concerned, no disadvantage pointed to in terms of employment or benefits or pension or civil partnerships. The NHS, as we've seen, was focused on justified medical intervention, not law. Again, I don't want to get sucked into an invidious debate about pure extent of prejudice, but I do submit that the prejudice which is suffered here, and there has been some, of course, we recognise, is at the lighter end of the scale and is not comparable properly with the position of transsexual people considered in, for example, Goodwin. And we note in our skeleton at paragraph 38, if one has focused on the Australian example for the security purpose, but one can focus on the Australian example for other purposes too, and the point that is made in para 38 of the skeleton by reference to the evidence there referred to is that even in Australia, where there is that system for X in the passports, there's been a very, very light take-up. 141 only in Australia since 2003, I think, is the number.
One would need to be careful with that, because the system in Australia, as I understood from the evidence that was with us, is that it was initiated only for intersex. And that may well have determined how many people sought it. I simply don't know.
My lord, it might, but it's a small number even in relation to those. So I'll check that reference to see whether we know more about that. But at the moment, it's a short and light point, a small number. The real sting in terms of impact, which my learned friend majored upon, was the materially false declaration. And of course, I'm entirely content to accept some prejudice as a result of those feelings in having to identify as female. My submission is one shouldn't overstate that.
It also, as I understand it, on the application form has to be, as it's put somewhere I read, verified by a statement of truth. Now, quite what form does that statement take? I mean, does it expose one to penalties if one doesn't?
Well, I think that was the point that the learned judge was grappling with at paragraph 115 of the judgment, was it not?
Sorry, I may have forgotten he dealt with that point, but it just struck me as, I mean, it could be quite significant as to, if it's like a statement of truth in a legal context, it could be really quite a serious matter. I mean, a very serious matter to have to effectively.
We've got a copy of the
We have a
form in
copy
our
of the
bundle,
form,
haven't
don't we?
we?
Yes.
No doubt
I'll
it
find
will
you the
tell
reference
you
for
if
that.
you're.
Tell us.
But I was thinking about it is at 115 of the judgment.
Thank you.
It's really the last 5 lines of 115. Is that the point that my lord had in mind?
Yes, I think you're right, it is. It's not strictly necessary to make a false declaration.
Because in the absence of selecting one of the two gender options, the
Yes, I'm
gender
sorry.
should be.
Yes, I see.
You don't tick the box, and somebody ticks it for you.
Yeah.
By
But
looking
at
at,
least it gets you out of that dilemma. It's a point of limited.
and it certainly implies, therefore, that there's no penalty for not putting anything in the box. Thank you. Yeah.
I'm helpfully reminded again in relation to the Australian point, so I don't lose it if my lord's notes are still there. This is in O'Neill 2, para 24. O'Neill 2, para 24, supplemental bundle 6 at page 76. And I think from what's been whispered, it was intersex originally and then changed to include non-binary in 2010, I think. Maybe my lord's memory, but that's where you have the Australian. Thank you very much.
Yes.
We have the Australian. So that's what we say about the third of the factors.
Now, I was looking both to the guidance that we've got in the bundle and also the actual form. neither of them cover the bit that tells you the penalties for making
I'll
an
see if we
inaccurate
can-
declaration.
See if we can trace that.
I think it'll be in the main guidance.
Yes.
But helpfully, we were only sensibly, I should say, we were only given
Limited
guidance about
selection.
20.
I'm proceeding this. I'm
No,
told
I'm grateful as opposed to critical, but
Yes.
that's it.
I'm proceeding on the basis that 115 last few lines is right.
Yeah, I'm sure that is right.
My hands are together.
Just the old habit of going to a source material, I'm afraid.
Devoutly discouraged when the judge has made a helpful finding.
I mean, what one might prima facie expect there to be some penalty, because after all, the passport is, for all the reasons we've heard, we all know from our personal lives, a very important document. So one would expect application for it to be a commensurately serious matter. And indeed, we know it takes a long time. There may be a number of reasons for that.
I'll double check to make sure.
Okay.
there's no-
Yes.
I want to make two final points going to balance effectively. And then in the period before the short adjournment. So we're beyond the three factors. These are just 2 points that go to the overall striking of that balance and the interplay between the three factors. The first point is to simply remind the court that there is ongoing consideration. Skeleton Para 35. We've set out in that paragraph the chronology and the highlights, and there is ongoing work by the Government Equalities Office, including important work to develop the evidence base which will inform the policy, including the analysis of issues and detriment and so on. See, for example, O'Neill 1, Paras 31 and 33. Some of those preliminary findings are set out in O'Neill 2, that's behind tab 6 of the supplemental bundle, but with a strong emphasis that work is ongoing. And that includes consideration being given to consulting on the introduction of legal recognition for non-binary or non-gendered people by amendment to the GRA. No decision yet taken. And you also see the updated position to the extent that it's relevant, but at least it's helpful to see it in the statement of Oliver Entwistle from the GEO that you've got behind tab 7 of that supplementary bundle. Too little, too late, says Miss Gallifant. That submission was made below and was scrutinised with conspicuous care and indeed critically by the judge. See especially paragraphs 122 to 126 of the judgment. The punchlines of this point are really first proper and proportionate work. The issue is live and it's under consideration and it includes the broader issues about status. Secondly, that work is illustrative precisely of the evolving context, with issues in the foothills of analysis and consideration, with emerging evidence and the evidence base still not fully to hand. Thirdly, it doesn't deny the existence of groups that are non-binary or non-gendered. So Neil's evidence is entirely clear on that. The question is what to do and when. And finally, in those circumstances, there is no proper comparison with the position as it was in Goodwin. The movement for recognition of a third gender or different aspects of a third gender, in this country at least, is tolerably recent. And that consideration does raise complicated issues, and we are active. The second point I flagged earlier, and I make it briefly, but it relates to the right constitutional body within the UK system for making this change. You've seen from the reference I just gave you to the consideration in Miss O'Neill's witness evidence, to the consideration of amendment to the GRA 2004, to the possibility of legislative change. But the submission is a rather broader one here, which is that the Secretary of State is entitled to be cautious, and very cautious, about introducing this sort of change, i.e. passport, without legislation about status, or at least without that sort of legislation having been fully and properly considered. You've seen the wide array of primary legislation which is premised on the recognition of two sexes only. See, if you want the reference back into the evidence for that purpose, O'Neill 1, paragraphs 12 to 14, 60 to 71, and 75. You know that in the context of trans people, it's possible to change gender, effectively legally to change gender, but the consideration of their position, the consideration of the changes that were made in the light of the Goodwin decision are perhaps indicative of the sort of changes that would be needed and that at the very least would need to be considered. All the more so because that position in relation to the current two-sex position is used as a distinction, and the distinction, in a variety of government functions, summarised again in Miss O'Neill's evidence, the first of her statements, paras 16, 72 and 73, and then 90. And that all leads to the position that if there is to be a change, it might be thought to be entirely appropriate that it should be for Parliament to make that change, but certainly not for the courts to make it. And that starts with the consideration of recognition and moves to particular incidents, the point I've made before, with all the issues that arise in relation to both of those limbs. And they are, it might be thought, paradigmatically legislative type decisions. And if there is to be a decision about broader status, then coherence plainly would require primary legislative change. And it's really as part of that broader coherence position and as part of this sort of aspect that the costs of change become relevant. True it is that the costs in relation to HMP alone are, if one wants to call 2 million an insignificant sum in governmental terms, relatively light. But you have figures being given in addition for the costs that would be associated with broader change in Miss O'Neill's statement number 1 at para 74. I think the only one of any substance that's so far been estimated is for MOJ, where it's 3 to 5 million. So no doubt there are other costs that would be associated with broader changes, and again that simply goes to reinforce the idea that there are broader ramifications, and that it may well be thought to be appropriate for that to be subject to parliamentary consideration. Well, that friend didn't make much, and so I can respond very briefly, nearly as much as she tried to do below, of the fact that there is Scottish legislation. I think there's one piece of Scottish legislation that refers to sex other than M or F. And the short answer to that is that that doesn't take one anywhere. It was a decision of the Scottish Parliament, and the coherence we're talking about is the UK position. And in any event, that legislation was in a thoroughly specific context, which simply doesn't demonstrate that there will be no difficulty and no incoherence if only you were to just make the change in relation to X in the passports. Now, lady, my lords, that takes me to Article 14 and the remaining issues, and it may be appropriate to break there.
Yes, that's that. Shall we
I'm allowed to break
for the?
there.
Yes, it sounds sensible to break.
I
for the
don't
short
think I'm going to be much more than about 3/4 of an hour after the short adjournment, so we should be well within time, subject to questions from the court.
Excellent. Thank you very much indeed.